Good morning, and welcome to the Brexit Readiness briefing from the British Ladder Association. The British Ladder Association? Ladder Association. I'll get this right, yeah, I promise. My name is Neil Amner. I'm a director at Anderson Strathern. We're a Scottish-based, full-service, independent law firm based in Glasgow and Edinburgh. Back to editorial, over and done with. Wearing another hat, I'm also the immediate past president of Glasgow Chamber of Commerce and a board member of Scottish Chambers of Commerce. So some of you may have heard me droning on the Radio Scotland in the morning about economic things as well. This morning's briefing is obviously about preparing for Brexit, whether it does or doesn't happen. We can maybe come to that in a moment. Sorry, before I do that, I will join in a moment by my colleague Paul Brown, who's one of the partners in our employment and immigration team. First, I'll scene setting, and then we'll go through some topics as we go through. So I suppose the big question, first of all, is this going to happen? Where are we? As you've seen from press coverage overnight, we're awaiting the EU's decision on whether or not there will be an extension to the Article 50 deadline. If we don't get that extension, then the UK will leave the EU at 11 o'clock next week on the 31st of October. There's also the possibility that the renegotiated Brexit agreement deal the Prime Minister has provisionally struck with the European Commission, it does go through. That may be unlikely at the moment in terms of current timescales. We'll see what happens. If that is agreed, if the withdrawal agreement bill does pass through our Parliament, then we enter into a transition phase. And at the end of that transition phase, which provisionally will be until 31st December 2020, there's a possibility that that timeline extends, and during that period we effectively stay as members of the EU. Sound okay? Otherwise, with the exception, I should say, of some of the employment and immigration provisions which Paul will touch upon. At the end of the transition period, we need to have phase two. If it's been torturous enough this far, getting this far, this is only the first step. The second step is to agree the future trading relationship with the EU. If we don't agree anything, then effectively we end up in the no-deal situation. So if we exit the EU without an agreement in place next week or whenever, or if we fail to reach an agreement with the EU at the end of the transitional period following an agreement, we effectively end up in a no-deal situation. So that's the sense in which we're talking today. So remember that this no-deal scenario may happen immediately or may happen in, pick a date, 14 months, 2 years' time. Confused? You will be, I promise. Anyway, by way of background, we will try and cover as much as we can today in terms of what we know, bearing in mind so much is currently still up in the air. For further information, we do have two things to point towards. One, on our firm's website, which I'm sure the team here can give you details of afterwards. We have a specific Brexit hub with articles and updated information as we go along, which we can refer you to. And equally on that, and we've got some hard copies for those in the room, we've prepared a Brexit checklist, which effectively it's for free. You can download it off the website. Just an idea to allow you to focus on different aspects of your business that may or may not be affected by Brexit. So some questions on people, on your trading locations, your existing knowledge of customs and tariffs, your ability to export, how much data you've passed across Europe, intellectual and brand property issues, your regulatory framework for your industry, and also financial implications, and then contracts and disputes matters. Happy to get copies sent round, and we'll leave some copies for those in the room here. I'd like to pass you on for the next few minutes to my colleague Paul Brown, who will talk about the employment and immigration issues. Paul.
Thanks very much, Neil. So one of the key issues and concerns and questions that's asked is what is the impact on employees, either employment law and more particularly immigration. In essence, in employment law terms, it should be business as usual for now. That's as much as we can say at the moment. Indeed, in 2018, when, if you remember, because we don't have that short memories, Theresa May was then currently the Prime Minister, she said that as long as she was Prime Minister, there'd be no change to employment law post-Brexit. Well, things change very rapidly. So we can't be certain, but at the moment the idea is that there will be very little change to employment law, certainly not overnight. What may change over time, particularly are the aspects of employment law that the UK have always been reticent to embrace. Things like transfer of undertakings regulations, which the UK have never really fully embraced. In fact, we have added to them in some respects, but we would like to change them. Also, the working time regulations, as you'll be aware, there is a 48-hour opt-out in the UK, but there wouldn't be that if the UK hadn't insisted on it. The rest of European cousins essentially weren't bothered about that at all. They didn't want anyone to work any more than 48 hours, but the UK insisted on there being ability to opt out. It is fair to say that in the UK, we do tend to work longer hours than most of our European cousins. So things like that may well change. Agency worker regulations, possibly flexible working regulations, but in principle, very little will actually change for now. That's as much as we know and as much as we can say. But obviously the area that's principally affected and will be affected is immigration, and obviously employment status in that regard. At the moment, as you'll be aware, and possibly till next Thursday, the end of January, or sometime into the next millennium, there will be free movement of European Union nationals. However, if we Brexit, the whole principle is, and intention is, that that will no longer be the case. So we are now looking at immigration rules. Of course, there are 3 million EU nationals that are currently living in the UK and indeed working in the UK, and in the majority of instances contributing tax and other provisions to the UK. So how do we keep these people? How do we actually allow them to work? The government at the outset, immediately post-Brexit, they allowed EU nationals to apply for permanent residence status in the UK, which at that time involved an 85-page form, which was never designed for EU nationals. It was designed for nationals from other countries such as China, India, America. Didn't matter where you were from, and it required all sorts of hoops to be jumped through about how long you've been here, when you've not lived here, etc., etc. That clearly wasn't appropriate. So the government intended, and indeed ultimately have introduced, what they call settled status. So the scheme applies to EU nationals, including those born in the UK but not holding British citizenship, and spouses and civil partners of British citizens. Those born in the UK but not holding British citizenship, that is quite a significant issue, much more than a lot of people realise. There's an awful lot of children born in the UK that actually don't hold UK passports because they hold the passport of where their parents are from, Spain, France, Belgium, doesn't matter where. And they've never actually got their own passport. They've got a passport in those countries, but not in the UK. But it also applies to some non-EU nationals, including the spouses or civil partners of EU nationals, children, grandchildren, and great-grandchildren, if they're under 21 years old, dependent children over 21 years old, that's perhaps those that might be still in full-time studies or with disabilities or other requirements that make them still dependent. Dependent parents, grandparents and great-grandparents. Again, some of our European cousins live a lot longer than we do, so great-grandparents can actually happen quite often. But those individuals, there are more people than you realise that are actually living here, who are here because their families are here and they're from Greece or Italy or wherever it may be in Europe, and they come and live here because they're dependent on their children who now live here. And then it also applies to unmarried partners or other dependent relatives who hold a residence card proving the relationship. Again, it's all very technical, but there are a number of people that can piggyback on applications. It also applies to EU nationals with a permanent residence document. Again, to date, not all EU nationals require, they don't have to have the passport to move around Europe and indeed to enter the UK, as long as they've got their identity card from whichever country they may be in. That at the moment is sufficient. It will not be post-Brexit, and they will have to have a passport effectively to come in. But also, if they are here on a permanent residence document, which is they've come here, they've registered here as working here, then that would allow them to consider the settled status. Separate rules apply to Irish nationals. but not their families. Now, Irish nationals, and you will have heard all sorts about the Good Friday Agreement and other arrangements in Ireland, it's very different. There is nothing to prevent Irish nationals still coming to the UK, even post-Brexit. So they still have separate rights from others. So the idea about settled status is that you come here, if you're here, you can register that you are here and you can continue to work here. It applies where you've continuously resident in the UK for 5 years or more. So if you've been here for 5 years or more, you can apply for settled status. The process is intended to be straightforward and user-friendly. Now, those are inverted commas because those are the government words. However, it is actually quite straightforward in practice. Applicants are only required to meet 3 sets of criteria. They've got to verify their nationality and identity. They've got to establish their continuous residence in the UK and establish that they're not a serious or persistent criminal or pose a security risk. Strangely enough, that applies to everyone that we're looking for any immigration status in the UK. Verifying their identity and nationality at the moment can be just their nationality card. It doesn't need to be their passport, but the passport, absolutely straightforward, simple. At the moment, the way the process works, the government have actually, believe it or not, managed to deliver a system that is user-friendly. And you can photograph your passport with all the details on it, and then you can download that. Now, just for those that might be doing it for their employees or helping employees with this, it doesn't work on an Apple phone. Security situation with Apple is that they won't allow it, so it actually works on any other Android phone, but it doesn't work on an iPhone. But nevertheless, take a picture, send it. You will then get an application form. You fill in the other details. It can be done, I'm told, in 15 minutes. I don't do it. I haven't done it for him. I haven't required to do it for someone, but for employers that have had to do it, it can be done as quickly as that. Established continuous residence in the UK. Again, miraculously, this is where the government have actually managed to get all their organisations together. And so you can establish that by council tax bills, your HMRC records, anything of that nature, official government documentation, etc., can demonstrate your residence in the UK. I say for settled status, it's 5 years or more. There is a thing called pre-settled status, and basically that applies to anyone who lives and works here but doesn't have the 5 years. They can still get essentially settled status, but it's called pre-settled status. The 5 years is kind of obsession with a date because there are certain immigration rules about having to be here for 5 years before you can start applying for permanent residence, and then subsequently, if you choose to do so, for British citizenship. So that 5 years seems to have remained as a hangover from the other rules. But you can get settled status after 5 years or more, pre-settled status before. The irony is that the main thing here is that you are establishing your right to be and work here. And it actually doesn't matter technically whether you've got pre-settled status or settled status. If you have pre-settled status, once you get past 5 years, you are then entitled to get settled status. So it's not really a big issue. There's no need to meet the knowledge of language and life in the UK requirements. Again, for anyone out with the EU or the EEA, there are certain rules about if you wish to apply to remain in Britain, become a British citizen, you will realise that you have to have a knowledge of language, i.e. English. You have to get a certificate that demonstrates that you have sufficient knowledge of English, and that you then have knowledge of life in the UK, which I don't know if anyone's heard of them, but you will see the British citizenship tests include questions like who was the King of England in 1312 and other such things. I wouldn't have a clue. I wouldn't be able to get British citizenship if I had to complete the test. And I challenge anyone out there to answer that question. You can Google it while I'm doing this. There is also no need to demonstrate that they hold health insurance or to pay the health surcharge. Again, this is another issue that, of course, and it's one of the emotive issues about European unions, is the idea that there's free movement, and of course, EU nationals can come to the UK and be in the UK and access the National Health Service. Of course, in theory, we can do the same in other countries as well. They have different systems, but we can get free healthcare in other EU nations. Individuals from out with the EU, of course, can't get that. And if they're coming here and they're applying for work visas or any other type of visas, they have to demonstrate that they hold health insurance or that they pay a health surcharge. Obviously, for settled status, that's not going to apply. So it's a special category of recognising people who are here, who have been here, and have the right to be here as EU citizens. They should be here before we Brexit. Now, whether it be phoning your friends now and telling them to get here next week before they definitely we leave, or otherwise, I don't know, but they would need to be here. There is a transition period to the end of 2020. That's for people that are already here or here before the date of Brexit. If you are an EU national and you are in the UK before we formally Brexit, you will still be able to apply for settled status, or obviously pre-settled status if you have less than 5 years. You would still be able to apply for that, but you have to be here, and you would have to do it before the 31st of December 2020. If you're not, and you arrive after we Brexit, there is a different rule and system that is going to apply for EU nationals, where they can stay for a period of time, but after a maximum of 3 years, they would then have to apply for British right to remain and residency in the same way as any other national from any other country around the world would. So the rights with settled status essentially are that you may apply for British citizenship if eligible. Again, that's about time and how long you've been here. If you've got permanent residence and settled status, then once you get that, usually it's 6 years to apply for British citizenship. So obviously, once you've got it, you've actually only got a year or so to wait. They may work or study in the UK. So if you've got settled status, you are allowed to work in the UK freely, and you're allowed to study in the UK in the same way as UK nationals are. They may access the National Health Service. So just as they do now, they would be able to access the National Health Service. They may access public funds, i.e. they get benefits, etc., obviously just in the same way as anyone else would, but they can access public funds. And they may travel in and out of the UK. Now, my understanding is, and no one's yet to contradict me on this, is you don't actually get a certificate that says, I have settled status. What it is recorded on our immigration systems. So there is nothing to prevent you going in and out of the UK once you have settled status. So if you are an EU national, you will still have essentially free movement. It does not mean, and if anyone's asking these questions, it does not mean that you have to give up the passport of or nationality of your original birth nation or home nation. You can still retain that. This is just a right to continue to come and go from the UK and to live and work in the UK. So it really is designed to try and encourage people to stay here. And as I say, if they stay here, then over time, should they choose to do so, they can apply for British citizenship. Moving back to Neil, will take us on to the next thing.
Thanks, Paul. Thanks very much, Paul. So I'm going to look at some commercial aspects of Brexit. The first thing I should perhaps say is that if you are, as a business, used to exporting, trading with the rest of the world out with the EU, then apologies, but a lot of what I'm going to say will be known to you, familiar to you, but there are a few tweaks to it. For those who don't export wider than the UK or wider than the EU, then hopefully this should help give a bit of structure to the way ahead. Effectively, the thing to remember is that to date, whilst we're members of the EU, sending a consignment of whatever, an access tower between here and Paris is the same way as sending from from Glasgow to Preston. It's as if we're in the one country in terms of the paperwork you require, in terms of the legal compliance you have to go to, and there's been no need for documentation other than your standard, your guarantees and your consumer information packs. And there's been no customs checks, no customs tariffs to be paid, no import VAT to be paid. I'll go on to what free trade agreements are in a moment, but where we have existing agreements where the EU has free trade agreements, so they have an agreement with Canada, for example, which allows for special treatment in terms of the customs tariffs that are due for imports into the EU from Canada, and also assimilate some of the non-tariff barriers, it refers to them, some of the red tape issues and the standards issues of trading internationally. Now, you might remember a while back, I'm showing my age now, but there was back in the early 90s a big issue about skis manufactured in the UK couldn't be sold in Japan because they had different snow from us. Snow, isn't it? Am I missing something? Maybe I am. Anyway, one of the phrases you hear bandied about during all the Brexit debates has been about WTO rules, the World Trade Organization. What is it? Who are they? The World Trade Organization is part of effectively a UN family of bodies. There's a series of international treaties and conventions, starting off with the GATT, the General Agreement on Tariff and Trade, which followed on shortly after the Second World War. It's part of the initial suite of UN documents. And since then, there's been a series of further conventions and agreements which have built the body of law, the body of international treaty law, amongst the various member states of the UN who've signed up to it. WTO as such is a body, it's based in Geneva, it has a secretariat, there's also a judicial function to it, which we'll maybe touch upon later. The essence of WTO rules are that insofar is that it regulates the relationships between nation states around the world in terms of trading between those nations. So the level of customs tariffs that are charged, and also the assimilation of non-tariff barriers. That thing about the red tape, oh, you can't sell that here, you haven't got it, whatever, it doesn't comply with this standard or that standard. That's what WTO seeks to regulate. The important thing for us as we leave the EU, and until we get a free trade agreement, come back to that in a moment, is that for WTO purposes, we are what's called a third country. So insofar as the EU is a member bloc, effectively think of the United States of America as a federal arrangement, a single nation state with states within it. For international trade purposes, the EU is the same as the USA. It's a trading bloc, it's a trading nation. And just as Trump is talking of building his wall around the Mexican border, so effectively from a customs perspective, the EU has a ruddy great big wall around its coastline for us going forward. So if you're a member of the club, if you're a member of the EU, then you are within that single market we've been referring to in the customs union so far. If you're not a member of the club and you haven't bought yourself through a free trade agreement, a special pass to get preferential treatment, then you're a third nation. And what that means is that you then are subject to the EU's WTO goods schedule, which is basically, it's a bit like a really boring index of a series of categories with an 8-digit code which describes various types of products in actually quite mind-boggling detail, and you have to be very careful. There's a drop-down menu. Fortunately, these days it's online, so it's easier. 20 years ago, you got literally an old-fashioned dictionary or Bible picked at your choice. You had to thumb your way through to find the right code and to flip between pages. Was it that one, or was the final digit a 5 or an 8? I wonder what I am. It's a bit easier now. It's all online. But effectively, you need to get the right tariff code to identify what your product is, to then identify what the tariff is. So, for example, the EU's current external trade tariff, which is the general applicable one, there are special exemptions if it's a free trade agreement with Canada, for example, but if you're bringing a vehicle in, say a motor car in from elsewhere in the world into the EU, it was a 10% customs tax duty is payable on that. Which means if we're a third country going forward, after we leave the EU without a special deal, then we will have to pay 10% when you seek to export. When you export a car from the UK and it arrives at the docks or wherever in Europe, to get that thing into Europe to onward sale to a retail customer, you'd have to pay 10% duty on that. For your membership, I had a quick look last night, and aluminium tube products, which I guess is what access towers and ladders would be. Don't take my word on it, check with a freight forwarder, but the EU tariff on that, and their published schedule at the moment, is 7.5%. Remember, when we no longer are members of the EU, then the EU's tariff doesn't apply to imports into the UK anymore. So we have to have our own tariff schedule. The government published a provisional draft of that in March. It was updated again last month. Sorry, this is my laptop updating in the background. Apologies, my IT systems are playing up. Anyway, so currently on your aluminium products, aluminium tube products, the tariff, there's no tariff specified in our draft schedule. I'm saying a draft schedule because it only becomes live once we actually leave the EU. So it's there on the Get Ready website, the gov.uk website. You can look at it, you can check it, but it's not live yet because at the moment we're still governed by the EU tariffs for things from out with the EU coming into the UK. And obviously, at the moment, trade between the rest of the EU and us is still part of that club, so there's no tariff payable. One of the issues with WTO rules and some of the hot air that politicians have been throwing around is about, oh, we'll do a special deal. It is possible under WTO rules to have an emergency waiver of tariffs, but that would have to be a blanket waiver of tariffs. Remember, the reason for, one of the reasons nations impose tariffs is a bit like Trump is having a trade war with China at the moment, is to protect your native industries from cheaper competition from abroad. You slap a tariff on something so that that cheaper import suddenly becomes more expensive than the domestic product. You put non-tariff rules in so that actually, we'd like to buy your Chinese whatever, but you know what, says Trump, it doesn't comply with our technical standards. Our consumers won't be safe. Think chlorinated chicken here, folks. Therefore, you can't sell it. So, most favoured nation rule is you can't do a special deal for one-off products with your best mate from abroad. If you're going to do an international trade agreement, if you're going to change your tariffs, then we can't just make Azerbaijan steel aluminium towers with less duty than those from Paris. We have to apply the same duty to the products wherever they come from. And the other thing about free trade agreements is that they are to apply to all the products from that particular nation. So free trade agreements effectively are a bilateral agreement. So it's an agreement between us and the EU, between us and the USA, us and Canada or Caribbean countries. It can be from more than just the one country. So that's why the EU as a trading bloc has done deals with the likes of Canada. We hear a lot from Liam Fox's department that they are going to roll over existing EU trade deals with other nation states as we leave the EU. Effectively, the theory is we go to China, we go to Japan, wherever, and we say, see that deal you've got with the EU, you know what, we were members of the EU, let's just apply the same terms to this. In theory, that's easy, but actually, remember, everybody in those trade deals, the EU trade deal has been subject to special lobbying by France and by the French farmers and the French wine industry for extra protection or extra concessions, depending which way you're trading for them. We won't have the same concerns. We might have actually wine actually in England, but the areas of industry that we want to promote or protect, the export markets we want access to, are not necessarily the same as those of the wider EU group, EU bloc would want in their negotiations. So it may well be possible that we can roll over some existing agreements with or without tweaks. But subject to that, because of that complex nature and the whole economy-wide nature of a free trade agreement, they are notoriously difficult to conclude, long and tortuous, with a lot of brinkmanship on both sides. And the normal period to agree a free trade deal, I am told, is anything between 5 to 8 years. So the idea that we will have free trade deals in place with most of the world economy by whenever next year seems hopeful at best. We may do it. If we do, fantastic. If we don't, then back to my analogy about Trump and his wall. The EU is this walled off club that we will have to, suddenly we become, it's a bit like everything else. If you're a part of a sports club or a social club, one safe and another, and you go and you have a big bust up in the bar one night and you storm off and you leave, don't expect to be welcomed back the following morning with open arms, is all I'm going to say. Okay, enough of the semi-political paranoia aside. the practicalities then, what do you need to do if, as a UK manufacturer or trader in products, you're bringing material in from the EU after Brexit in the absence of any special deal? So this is either a no-deal Brexit or in the absence of a free trade agreement, what do we do after the transition period? And even if there is a free trade agreement in some shape or form, some of the paperwork I'm about to talk about, the process I'm talking about may still apply, or the actual tariff, the percentage applicable may vary. So on importing, import duty, customs duty is payable on imports, generally at the point at which they land in the UK. Equally, you have to pay VAT on imports. And that, the calculation for the VAT in imports includes the costs of the costs and the duty already paid. So your customs duty inflates the amount of VAT that you have to pay on the import. In terms of VAT, you need to get a form C79, which is the import tax certificate from HMRC, to allow you to reclaim the input VAT. And timing, you pay it on importation unless you get a deferment account set up with HMRC. That basically allows you to pay it by way of that quarter return. To do that, HMRC asks that you provide a bank guarantee. Again, so that in itself can be problematic for SMEs, but not the end of the world. There's also an additional procedure called simplified VAT accounting, which if you're a regular importer, then you can get that. That reduces the level of the bank guarantee required from HMRC. Confusingly, there's also another thing called transitional simplified procedure, specifically introduced for the transitional period as we exit EU, which is a two-stage declaration process, again, which allows you to defer the payment of the VAT. And for those things, I'd simply, beyond the scope of this talk, but if you have a look at the HMRC website for guidance on that. In terms of exporting, I'll come to some of the actual paperwork required in a moment. But again, for us, unless you're exporting something like whiskey or beer, something where there's excise duty on alcohol payable on export, the actual act of exporting isn't taxed. You pay customs duty when the product lands at wherever you port in Germany or Holland or whatever, as you import into the EU, or for that matter, our nation states. In terms of materials, so if you're bringing in materials to then put into a finished product, which you then export, you can apply for what's called inward processing relief, which is for goods being imported, processed, and then re-exported again. That's in terms of our position, our customs and VAT position. From the EU's position, if the materials are coming from the EU to the UK to be processed and then re-exported back to the EU, you can get what's called outward processing relief, flip side of that, and effectively you pay duty on the added value rather than the overall cost of the finished product. Again, that's an accounting thing. Don't ask me detailed questions about it because I'll expose how little my knowledge is, but it's something you have to check with HMRC, or for that matter, speak to your freight forwarder or your accountants for detailed advice on that. For those processing reliefs, you need HMRC authorization for that, and you need to be what's called the importer of record. So that is, if you're the tower manufacturer who's bringing the components, then you are the person who pays the import duty on those components on the way in. It's possible to pass that importer of record status from one organisation to another, so that you can then get the benefit of relief, but you have to comply with what's called TORO, the Transfer of Rights and Obligations mechanism. Alternatively, stuff that's being held for export out with the EU, you can hold it in a customs warehouse for temporary storage in alcohol terms in a bonded warehouse. The other thing to mention is the thing called the Common Transit Convention. So this applies to the EU and additional countries around the fringes of the EU, for example, Turkey and Switzerland are covered by this. This is the idea that if you comply with the requirements of the convention, then you don't have to have interim customs paperwork and interim customs tariffs payable as your consignment moves its way across Europe. So a good example in the future would be sending a consignment of ladders manufactured in Scotland. down by truck over the channel ports into France, and then on a train or something, and then heads down towards Turkey, and then it's for sale in Ankara. You simply set one set of paperwork when it leaves Scotland. You pay the customs duty when it arrives at the final destination in Turkey, and there's minimal checks along the way and no customs paid along the way for that. But you have to comply with the requirements of the convention. Again, for that one, best one to check to is either speak to your local Chamber of Commerce or your freight forwarder to help you with the details of that. One of the logical questions, and one of the things actually that none of the official guidance actually explicitly covers, is what happens on day one? What is the status of stuff on the day after we leave the EU? So this might be unduly simplistic with a lawyer, but I think it's actually quite clear. Whilst we are members of the EU, materials moving to and from the continent don't pay import duty. Once we've left the EU, import subject to the free trade stuff and all the rest of that side, we have to pay duty. So I think the test actually is physically at 11 PM on 31st October or whenever, 31st January, whenever it is that we leave, if we leave, where is the stuff? If a material that's coming from the continent has already arrived, is physically on the quayside in the UK, then it arrived in the UK whilst we were members of the EU, and therefore logically no import duty is payable. Likewise for a consignment sitting on the quayside at Zeebrugge or anywhere else in the continent. If it's not in country, if it's literally at sea whilst we transfer, then I think duty would be payable at the point at which it arrives, be it in the UK or in the continent, once we've left, because by that time we will not be members of the EU, and therefore the customs obligations kick in, I think. But as I say, it's not actually said as much on any official guidance, so check. Contract issues. Before I say any more, I think the important thing here is that everybody, from lawyers and accountants to manufacturers of products to construction industry, people to hire companies, everybody actually is part of a supply chain, like it or not. As a consumer, as a manufacturer, there's usually somebody upstream or downstream from you, your supplier, your customer's customer. And thinking of all the Project Yellowhammer and all the different official concerns and some of the political rhetoric that goes around this, and some of the very justifiable concerns, particularly from the trade organisations, particularly from the freight and logistics sector, and the retail sector for that matter, we need to think about the knock-ons that what person A's, business A's consignment, not arriving at the required place at the required time will have for their customer, but also their customer's customer down the line. And there comes a point where actually you stop being able to pull the thread and figure out what the knock-ons are. So it's kind of three things here. One, the actual mechanics of the contractual issues, what contract terms you use, what your relationship is like, the insurance implications, the cash flow implications, but also the wider relationship implications. And before we get into the legal stuff, I'd just say actually the best bit of advice I think we can give to anybody is, if, as you sit and think about where you sit in the supply chain which you form part of, have a conversation with your suppliers, have a conversation with your bigger and more important customers, and try and agree on very pragmatic terms. If it all goes a bit pear-shaped, what are we going to do? How much stuff do you need to have sitting to keep you ticking over till the next consignment can arrive? Can we agree the cost basis of, can we give that to you? Can we pre-order? And actually, some of these conversations, if we extend next week without a deal, it's a bit late. But if we get an extension, there's still time to have those conversations, stockpiling conversations. But actually, how can you work together conversations? Okay. For those of us who are just used to simply trading within the UK or within the EU and not internationally, we probably won't have come across Incoterms in the past, so we have to worry about it. But Incoterms are the International Chamber of Commerce standard conditions for exporting. There's about a dozen of them. There are various forms. And basically, this is between the seller and the purchaser. This sets out the contractual arrangement. Actually, they are remarkably brief, remarkably simple documents. The implications can be bigger than actually the document looks itself, but the actual document is only 3 or 4 pages long at most. And it specifies the contractual arrangements. So For example, delivered duty paid at place specifies where the consignment is due to be delivered to. It deals with who is paying, who pays the customs duty and the transportation costs, all that kind of thing. So the price specified in the contract is the price duty paid to be delivered at a specified place. So the warehouse inland from the port at Rotterdam is where the consignment is due to be delivered 2 weeks on Tuesday, and if it's DDP, it means that the exporter pays all the costs of getting it there, and the risk of any damage to that consignment transfers when it physically arrives at that spot. That's the relationship between the seller and the purchaser. Incoterms contract, there are different varieties of look at it. There is a different question, though, about what the logistics arrangements are for getting that consignment from the point departure to the destination point. The Incoterms will say has an implication on that, but there are two separate contractual arrangements there, and indeed actually your insurance arrangements are separate as well. I've touched upon that domestic purchase and sales procurement chain issues. Certainly it's worth having a think about that very pragmatic conversation, but also if you haven't done so already, you can't do every single contract, but if you're using standard form contracts, have a look at them, see what they say, think about in a Brexit context, what that means for you, about enforceability as well, particularly civil judgments if you've got customers abroad. And certainly, even if you don't use standard terms, if you have, say, your top half dozen customers or your top half dozen suppliers, take those contracts out, have a look at them and say, right, scenario play it. What if, what does the contract say? And get some legal advice, get them tweaked, have a think about your relationship. It's also worth thinking about risk allocation. If because of Brexit, now actually for aluminium towers and for ladder systems, it's not such a big issue. It's a real issue for food and drink, particularly for the fish guys, but also fresh fruit and veg. If there are issues at the port, and bluntly the stuff goes off, or if the ports do gum up and we end up having these notional pictures of massive HGV trails and the rest of it, actually there are only so many vehicles and only so many drivers available in the UK and in the EU. There's a point at which the system grinds to a halt. That may be hysterical, maybe far-fetched, but theoretically it's possible. So risk allocation, what if it all goes a bit pear-shaped? What if even actually, if you've got, okay, maybe not for your particular industry, but if you have issues of if stuff doesn't arrive in time, and actually access towers, ladder systems aren't going to go off in the same way as fresh fruit is. But particularly if you're in a hire sector or you're supplying to construction companies who are going to use the kit for a project, if your kit doesn't arrive on site or at the wholesalers or at the hire company on time, or you're the hire company and the fresh load of stuff you're expecting to go out on a big job in 3 weeks' time doesn't get there, what does your contract say? Who's paying, what the damage is, and have you insured it? And the final point here is market norms. As a trade body or as a trade, there's a question of what is the generally accepted market position for your industry, for your sector, and particularly for your subsector of these kind of questions. It will vary from industry to industry where you are in the supply chain as well. There are some very real and practical implications there then about the day-to-day stuff. We've touched on stockpiles. Stockpiling has an issue for finance. It's cash flow. It also has an impact on your banking position. Most finance arrangements will have banking covenants, set of financial metrics, KPIs you will need to comply with. And I've heard stories in the construction sector, for example, that house builders have been required by the banks to have warehouses with a certain number of weeks of bricks and mortar and plasterboard sat waiting so that they can keep building, they can keep feeding the customer base, keep the cash flow going. That applies across the whole of industry. There are, through the major banks, schemes available for special Brexit funding coming down. Now the issue actually is, and again, elephant in the room situations, if you're in a strong financial position, then obviously the bank is going to fall over themselves to throw money at you to keep you afloat and keep you in that robust position. If If you're not in a strong financial position to begin with, and you go to the bank saying, I want money for stockpiling, I think my cash flow is about to go a bit pear-shaped because of Brexit. There's only one logical position for the banks to adopt, isn't there? Possibly. So there are Brexit pots of funds available. The bigger banks, the nationalised ones, I understand, are being fairly magnanimous about those situations, but clearly to avoid them getting into the pickle they got into 10 years ago, they are having to take informed decisions about how they allocate that funding. And again, I don't want to go off pitch in political speech, but there are issues obviously amongst that for us all to worry about. Okay, export documentation, and I'm going to apologise to those of you who aren't in the room in Glasgow. As the BBC would say, other chambers of commerce are available. In Scotland, there are, I have my Scottish chamber saying there are 26 chambers of commerce. Of those, there's the ones in the larger cities, so Glasgow, Edinburgh, Aberdeen, Inverness, and Ayrshire chambers of commerce are accredited with British Chambers of Commerce to do export documentation paperwork, and that is a government scheme under which, under BASE, under which export documentation is provided by the chamber network. By export documentation, what do I mean? So these are the European Community Certificates of Origin. Now, after we leave, obviously we will become a UK Certificate of Origin. Depends on your product, but this is very often, again, for the food and drink sector required. Our British Certificates of Origin are specific for those markets. ERU1s are preference documents, we'll explain them in a minute, and then ATRs are preference documents for Turkey. That's that preference deal I told you about earlier on. There's a free trade agreement, and it's to certify that the assignment qualifies for that preferential treatment. They also provide invoices and packing lists, import certification certificates, ATA carnies, I'll explain in a moment, and registration certificates. They can also arrange for notarization and legalization, which is the process of certifying the validity of documents under the Hague Conventions and other various requirements for international trade certification. So, certificates of origin, so the EU ones will cease to apply, or cease to be issued from day one, but the chambers do have a stock of UK certificates of origin ready to be issued. There's no change to our British ones. A preference document, an ERU1, allows an importer to receive either reduced or zero-rated duty at customs clearance. It's used for consignments of EU goods dispatched from the UK, or as in the EU at the moment, to preference receiving countries, so South Africa, Iceland, Norway, Switzerland, for example. The point is, absent the UK having its own free trade agreements going forward, they will cease to apply from day one, as will the ATR documents used for Turkey. An ATA carney is something which, again, if you're not trading internationally at the moment, you probably won't come across. It's effectively a temporary passport for admission into another carney convention country of specific items. It's generally used for commercial samples, for international trade fair exhibitions, and professional equipment. So actually, international trade fairs, you may be accessed to others that are being used to build exhibitions abroad and then brought back. So basically, it's a bit of kit. Actually, the oil and gas industry use this a lot because of some of the bits of kit they move around. It's sent abroad temporarily for a specific purpose. It's not sold as such. It's you send it there, it does its job, it comes back, and it pings backwards and forwards. So it allows the importer to enter goods without paying duties or taxes. How it must come back to the UK within 12 months, and there will be a need for these if we have a no-deal Brexit for stuff going to the continent. ITP2 is a Scottish Chambers Network initiative agreed with the Scottish Government. It provides Scottish Government funding. So the two refers to the second tranche of its funding. So it's Scottish Government funding to help Scottish-based businesses go onto an international trading footing to expand. There's a portion of the UK's non-EU global exports, Scotland in particular, has traditionally, in recent years, been very heavily skewed towards a very few industries. So in Scotland here, it's food and drink, whisky particularly, seafood, particularly salmon, but also actually defence is another big one of ours. So the number of companies who actually export is numerically is remarkably small, and equally the proportion of our total exports, which is driven by the top 20 or so exporters, is absolutely scary. So the idea of this is that we've been encouraged by the Scottish Government and the UK Government's Exporting is Great campaign runs in parallel to this, to build bridges, to build relationships. Actually, it's what the Chambers of Commerce network was set up to do originally. Glasgow Chamber of Commerce is the oldest one in the English-speaking world. It's formed in 1783 as a direct consequence of a certain bunch of Americans. Why is it always America, these things? Of Americans throwing bales of stuff into the harbour in Boston. The Boston Tea Party sparked off the American Wars of Independence. Prior to that, Glasgow obviously was a global centre of the tobacco and cotton trades. And this was the Glasgow merchants saying, right, what are we going to do? We fight over table scraps ourselves, or do we lobby government for better trading conditions? And that's what the Chamber has done over all these years. So it's kind of Glasgow's returned to our roots. So in the last couple of years, we have built partnerships with Germany, in Glasgow's case, with Düsseldorf, Nuremberg and Berlin on the back of the European Championships last year, Italy, with Milan and Turin, the USA, I signed an MOU with our counterparts over in Manhattan a couple of years ago when I was president of the Chamber. We've visited delegation to China as a group going out to Shanghai this time next month, and the UAE. These are both promoting inward and outward trade missions. So, for example, in Glasgow alone, in the last couple of weeks, we've had delegations from Rotterdam, from the eastern seaboard of the States, from the UAE coming as well. We're a Chamber of Commerce, be it Glasgow, Edinburgh, Inverness, or who are running an international trade mission. They are open to members and non-members of the chambers and other chambers across the UK, across membership. So if you're interested in a particular market, I want to target that, I would encourage you to go and speak to your local Chamber of Commerce, and they can plug you into the network and let you know when the next missions are coming about. And certainly in Glasgow, at least, we have what's called the 1783 Presence Network, which is a network of people with Glasgow connections in business internationally, our away team effectively, a global Scot idea, who, when we have members, trade delegations or individual members going into those local markets, they are prominent business people who have offered to make introductions and effects. So again, if your particular market you're interested in, please do contact your local Chamber of Commerce. And for those on the webinar, there'll be similar arrangements for the BCC network down south as well. A couple of quick high-level slides now, just to say that regulation, as we leave the EU, some of the product standards, some of the environmental compliance we need to comply with, and also the certification of that is going to change. In broad terms, initially at least during the transition period, and no doubt during the first couple of years post our exit, EU law, particularly environmental law and consumer standards, will no doubt stay the same. But there's the possibility through time that they will start to diverge. And equally, again, not so much for your industry, but for other industries such as again, food and drink and pharmaceuticals, the certification of compliance with standards, use of UK-based labs and being recognised on the continent for these purposes is an issue at the moment. So it's something, again, to look at, you'd have to look at the particular industry requirements, certification requirements for your products and get specific advice on it. Intellectual property and trademark brand protection is probably a half-day seminar in itself for those who are specialised in that area. All I would say is that there is a technical issue, but as we leave the EU for trademarks, that in terms of what, if you use a trademark in the EU, the brand protection for that, once we're no longer in the EU, there's a technical issue there, which is something which needs to be closed off and may well be covered. Data is that modern day phenomenon we all forget about till it's turned around and bites us in the bum, and again, there's some technical issues attached to it. The points to make there, and I'm going to check my own notes here because this is not my area of expertise. My colleague Douglas, who does specialise in this area, unfortunately, is at another meeting this morning. But GDPR, the General Data Protection Regulation, is an EU measure. Our Data Protection Act 2018 broadly mirrors GDPR, and in fact the government said that they will make further tweaks to that act to make it fully mirror the GDPR requirements. it's worth remembering in this context that GDPR, being an EU measure, will cease to apply as such when we leave the EU, but it is framed in an extraterritorial effect. In other words, it has effect out with the EU because it deals with the processing of EU citizens' data wherever that is processed. For those of us based in the UK, transfers of data to the European Economic Area, to the EU, the UK government said that be authorised. So there's no further steps required in terms of your internal processes or paperwork. Transfers from the EEA, from the EU to the UK of data. So actually, so if you've got UK customer data that you have exported to a data centre in Germany, you can do that, keep doing that, that's fine. Sending that data back, particularly if as well as UK citizens, EU citizens data from that data centre back to your server in the UK could be problematic, because under GDPR, to do that, once that receiving server is out with the EU, i.e. because we will be after Brexit, it needs what's called an adequacy decision from the European Commission, which basically says they recognise that the data protection laws of the receiving company are equivalent to, or provide the adequate protections for the EU citizens as they would have had under GDPR whilst in the EU. So if the Data Protection Act is assimilated, that's fine. In theory, it should be fine. But actually, the process of an adequacy decision is something that can take some time for the Commission to get around to doing. There are workarounds in the meantime. And again, the UK Information Commissioner's Office's website has talked about this, but there's a slight fudge in civil service language of how it's done. There's something called standard contractual clauses. So these work and they don't work. So if you are, in terms of passing data from EU citizens from data controller to data controller, from within the EU to out with the EU, and you use the standard contractual clauses, that will work. If you pass it from an EU-based controller to a UK-based data processor, that doesn't work under standard clauses. There is an issue, you're potentially in breach, or your data center in Germany potentially in breach for doing that. Absent this adequacy decision from the Commission, the system in theory could grind to a halt. Everyone is paranoid about GDPR breach. Actually, the workaround for that will be for the Commission to say that during the transition period, pending an adequacy decision formally being issued, they will not enforce GDPR breaches during that period. Sounds far-fetched, but actually that was the pragmatic workaround that the Commission came out with during the US safe harbour issue on data a couple of years back. Probably all I can say on that, and apologies if anybody wants to ask questions on that, I'm not going to be able to answer them, but I'll happily give you Douglas's contact details. Otherwise, you should take your own legal advice on that. I would certainly say it is very worthwhile to review your privacy information and documentation on the data issue as we move into the Brexit scenario. That, you'll be glad to hear, enough of my voice for a while, concludes the formal presentation bit. Let me just give you a couple of slides of contact details, and we can take some Q&As. These, I'm sure, we can provide association later. But that's my contact details, Paul's, and also Douglas, who is our data and intellectual property and trademarks expert back in the office. And for those of you based in Glasgow, that much Central Belt, here's some contact details from Cathy Bryson, who leads the export documentation team at Glasgow Chamber, and also Lane Roger, who runs the international trade, inbound and outbound trade visits. As I say, to be fair, there are other chambers of commerce across the country, particularly in Scotland, and they do work as a network. So even if you contact Cathy or Lane, they can put you in touch with their counterparts in the local chamber. And by that I mean Edinburgh, Aberdeen, Inverness, and Ayrshire, in terms of being able to process international trade docs. The wider chamber network do have access to ITP2 trade visits as well. Okay. On that basis, I will pause there unless there are specific questions.
There was a comment online, but it's probably more directed to Paul. It's not really a question, it was just a comment. We were talking about the settled status.
Yeah.
Just that it didn't work on their phone. It took 2.5 months before they got settled status. They have no confidence in the system.
Wow, 2.5 months.
Yeah.
That is.
And they have a German friend as well who had difficulty with the system also. So I think that's the comment really.
Right, that's certainly the longest I've had. Yeah, 15 minutes to be fair is the shortest I've ever heard, and that was a miracle. But 2.5 months is, yeah, that's a long time. The system is not perfect, and for a minute, I wouldn't suggest for a second it is. It took them a long time to actually put it in place. I suppose as far as the comments are concerned, all I can say is it's better than it was, or otherwise would have been. When this first started, post-Brexit, post the referendum, I had a number of people that I was advising, a number of universities and colleges. 11% of the staff, the academic staff at Scottish universities, are EU nationals. And they were very concerned. They'd lived here virtually all their lives, certainly all their academic lives, and we had to help them fill in this 85-page questionnaire. Some of them had to demonstrate how often they'd left the UK. Now, some of them had relatives, obviously, in Italy, France, Germany, and they had to put down every weekend they'd ever left. I mean, it was just ridiculous. So that's the intention behind it. Wouldn't profess it, but 2.5 months is the longest I've heard so far, so that's unfortunate. I think perseverance is probably what's required. What I meant to say earlier on actually was, and I think what's very important in this is that if you have staff who are EU nationals, get them to apply now. It doesn't make a blind bit of difference to their status in their home country. Get them to apply now, because if you know, it's better to do it right now, if you can, before we exit, whether that be next week or 3 months' time or whenever. But there is, as I said, a transition period. There will still be time, but that transition period won't apply in the same way to people that come to the UK after we actually exit. There'll be a different set of rules for them again. But if you've got staff here now, get them to apply, help them to apply. In some communities, actually, in the Romani community in London, they have very community-based thing, and they have cafes set up, and they are doing applications for them. So, you know, a lot of communities are helping themselves do this, but it's definitely something to do now. One of I mean, for example, in the tourism industry, I head up our food and drink sector. A lot of the stuff that Neil's mentioning there. Food and drink is going to be particularly hit, and also that includes tourism, food tourism. It's huge, tourism in Scotland. If all of the people left the UK, Scotland in particular, the EU nationals, we would be 80,000 people short of the number of employees we need to do the work. Just at the beginning of this week, I was reading an article on, and of course, people have talked about this. This time last year, the government, if you might remember, were crowing about the fact that our economy was still growing, blah, blah, blah. Yeah, well, that was when people were still uncertain, but let's just keep going business as usual. This time this year, not so, because everyone is paranoid about what might happen, no idea what's going to happen, so there has been a shrinkage. This time last year, people were worried when the referendum happened, what's going to happen with fruit pickers, what's going to happen with all these kind of people. Oh no, it won't happen. And to be fair, last year, it didn't necessarily happen. Not so already this year. This year, there is, now I think the figure, don't quote me on this, it's something like 60,000 tonnes of apples that haven't been picked. There are 8,000 tonnes of grade 1 strawberries in Angus. Now, those are the strawberries that sell to all the fancy supermarkets that haven't been picked. And the situation is the same up and down the country. And it's not just because of the uncertainty. Basically, that actually happened, not just about people saying, well, if you don't want us, we don't want you, and European nationals not coming here. It's actually the other impact of the value of the pound. Post the referendum, the value of the pound dropped by 20%. If you're an Eastern European national who comes here, works very hard, and sends the majority of your pay back home, suddenly that 20% isn't worth your bother. And so what they've done is they stop in Holland and Germany and other places. They have a shortage of employees as well. So why come all the way to the UK if in fact you can stay in Germany? You can only go as far as Germany and still send the money back home. So there are major issues in those sectors. But yeah, no, 2.5 months, my goodness, that's not what was intended. So, yeah.
Any other questions?
Comments, queries?
I'm on.
Yeah.
Heading off on holiday. I head off to Europe next
Yeah.
week on holiday for a week, and I'm away the potential date and arrive back sometime in November. How's that going to affect?
Oh, you won't get back in. Don't go. No, it won't make a difference, actually. It genuinely won't. I mean, obviously, the fact is that what's going to happen with holidaymakers, for example, if you were to come back, you're just a holidaymaker. Initially, it's only going to really affect those that are working or wanting to work abroad. It's not going to make a blind bit of difference in the short term. What the UK government have done already is there are a new, just so you know, there's a new Immigration Act due to come out in 2021. It's going to apply internationally. You'll have heard of it called using the Australia type rules, you know, points-based system. But that's for people to come and work here. Holidaymakers, there's a whole series of countries that already allow you to come here without a visa. The same would apply. Going to the EU, but they say we can go, as you'll know now, to any number of countries without a visa. The same would apply. So don't panic.
And your E1 card, how would that affect you?
That the health one, not so. Yeah, when we Brexit, that will not necessarily apply in the same way. That's another one of these transitional things that we're not quite sure. But technically, as of that date, because we are no longer in the EU, it won't. So to be honest, I would recommend that you have travel insurance. To be brutally honest, I mean, I know we're lawyers, you know, we're always paranoid about everything. See what you read about makes you react in a certain way. I would always take travel insurance anyway, but I would take it just in case for health purposes.
I think there's another couple of questions in the room, but they want to grab you just afterwards.
Okay.
And just speak to you directly.
No, that's not a problem. We'll catch you soon. Okay, great. Thanks very much. Thank you, everyone. All right.
So I just wanted to say thank you for Paul and Neil for coming along today. Obviously, they came to speak to you today as a result of the Access Industry Forum, working with the Hire Association Europe, because they got some Brexit readiness funding from BEES. So that was what enabled today's event to take place. And the webinar will be recorded and will be available online over the next few days. Thank you very much.